The broadcast is now starting. All attendees are in listen-only mode.
Go ahead. Good afternoon. I'd like to welcome you to Palermo's webinar on understanding OCI mitigation plans. We look forward to presenting to you on this important issue regarding OCIs and mitigation plans. It is an area of the law that we are regularly being consulted on. I have the privilege of presenting with my colleague, Michelle Litteken. Michelle and I have worked at the firm on many protests involving OCIs, and also we've worked over the years with clients who foresee when OCIs are coming down the pike and ask us to help them with mitigation plans so that they can be prepared in case there's a protest or in case an agency is asking them questions during a procurement process regarding potential OCIs. For those of you who have never attended one of our webinars, you know, our firm is regularly conducting webinars like this and also issues a newsletter on a quarterly basis, and on a weekly basis we try to keep our clients abreast on developments in the government contracting field, and generally any kind of development that we believe would be of significance to our client base, which consists of many government contractors and companies doing business with government contractors, which is why this topic is so relevant to our audience. With regard to the topics we're going to discuss today, we're first going to give you an overview or an introduction of what is an OCI. Before we can discuss mitigation strategies and mitigation plans, we think it's critical that the underlying regulations and case law and principles involving OCIs is understood by our audience. And then we're going to switch gears into how it is that you can identify different OCIs so that you can try to address them. We then will be discussing mitigation strategies for the three major types of OCIs that are out there: unequal access to information OCIs, impaired objectivity OCIs, and bias ground rule OCIs. We then will discuss the key elements in an OCI mitigation plan, and also considerations that need to be taken into account related to affiliates and teaming partners, as oftentimes companies that are pursuing government contracts do not realize that an OCI may lurk out there because of work that an affiliated company is doing or that a teaming partner is doing. Turning to the introduction to OCIs, what we'd like to do is go through these slides, which all of you can read up on your screen. There's no need for us to repeat what you're seeing here, but I think it's of critical importance that we try to put this in layman's terms. Fortunately, working with Michelle all these years, you know, I view her as a lawyer's lawyer because she does such a great job at explaining OCIs to GAO attorneys and other attorneys that consult with us on a regular basis because they don't understand this area of the law. But we also have many clients that do not have a legal background and find it hard to grasp what is an OCI. So I'd like to just basically turn this over to Michelle, and during the course of the presentation, I'll be asking you different questions so she can explain to you what these OCI issues are and how to address them. Michelle, if you could please explain to everyone, you know, in just plain English, what is an OCI?
So an OCI is a conflict of interest. So what does that mean? That means there's a concern that the contractor will obtain an unfair advantage or the government will not receive the services it bargained for because of some other activity, namely a contract, that company is engaged in. So that's how you get these three different kinds of OCI. An unequal access to information OCI occurs when a contractor has access to information that other companies don't, and that access could give it an unfair advantage. Or you have a situation where you're concerned about the government being able to obtain the services it bargained for, like an impartial evaluation, or, you know, the best advice on a solicitation and what requirements should be in there. And that's where you get into the idea that the contractor has some kind of conflict of interest because of other work that it's doing that's going to even subconsciously affect the services it provides under another contract with the government. And this, with all these different issues going on, it's a complex analysis. OCIs change over time. They're dynamic. If you're awarded one contract, you may not have an OCI at that time. But if you're awarded another contract that somehow overlaps with that contract because it uses the same kind of information or requires you to assess the work you're doing under that prior contract, all of a sudden you have an OCI. That's what we mean when we say OCIs are dynamic. And because they're so important, it's OCIs, the contracting officer needs to identify and investigate them as early as possible. So as a contractor, at the same time, you should be aware so you can assist in that investigation and help educate the agency and explain what's going on. And one critical consideration is that a contract can often result in more than one type of OCI. So you may have an unequal access to information issue and an impaired objectivity issue, and you need to make sure you're addressing both and not just one.
Okay, thank you, Michelle. Michelle, now with regard to the significance of an OCI, is this really something that contractors need to be worried about?
I would say most definitely. So, as you mentioned in the beginning, this can be the basis for a protest. You could be named for award, and then all of a sudden someone is protesting, and you could lose that contract because of an OCI that wasn't addressed or the agency didn't consider. It can also affect who you team with, what opportunities are available to you in the future. This blanket approach here that's referenced has to do with the government imposing blanket restrictions in RFPs saying this company can't do this work, or any company who held this contract in the past or this group of contracts in the past can't do this work. So it can really affect the opportunities that are available to a company.
Okay. And with regard to unequal access to information, OCIs, what kind of information essentially creates what is called an unequal access to information OCI?
So this is any kind of information that would give a contractor an unfair advantage. So the one way to think about it is, would you want your competitor to have that information? So that could be financial information, either other companies' information or the government financial information, or it could be information about a procurement that's not public, like a draft RFP, or the working documents that went into what requirements were included in a solicitation. So it could be financial, it could be technical, it could be related to a solicitation, it could be related to your competitors, but in sum, anything that would give you an unfair advantage over your competitors could be an unequal access to information, OCI. Now, importantly, it's not incumbency. Obviously, if you're the incumbent, you have a little bit of insight into what the agency wants. You have an idea of how much the work costs. You do have some benefit there, but incumbency is not considered an unfair advantage. So it doesn't usually give rise to an unequal access OCI.
So in the example that we have here, the incumbent had access to the information and was still deemed to not have an OCI?
No, so this company had access to competitor budget information, labor rates, and they were deemed to have an OCI, so they were not allowed to compete. So
that's not a situation where you have incumbency. So now, with regard to incumbency, then, what is the difference between an incumbent that has an OCI problem and actually may have a Procurement Integrity Act problem? Is there a big difference there?
Well, the Procurement Integrity Act, it often gets raised in the situation with contractors, but it's the words of the statute, the Procurement Integrity Act refers to government personnel releasing information. If a contractor had access to another company's proposal information through a contract, like that's what this example here is, this case, this company was supporting an agency, and because under that contract it had access to labor rates, maybe it was a financial contract or something, had access to that kind of information. So that's how you get into the unequal access to information issue. For a Procurement Integrity Act, you would have a company unlawfully, inappropriately getting another company's proposal. And that's usually not in connection with a government contract. That's usually happening outside the contractual process, and that's why it's considered improper.
Okay, and then with regard to this, incumbency is such an important factor in having a competitive advantage. At what point does an incumbent need to be careful with regard to information that they may be exposed to that could create an OCI?
So incumbency is rarely going to create an OCI under that same contract. It's when you're looking at other contracts. So if you are performing contract for a program management office, and as the incumbent on that contract, you're being shown information about other companies' cost performing other contracts within the agency, and then you want to compete for those other contracts, that's where your incumbency within the agency could cause a problem.
How about if you are an incumbent and you start learning about an agency's needs, you really understand now what they require? Couldn't a contractor that now competes with you for a follow-on contract argue that you have had unequal access to information?
So the unequal access in the procurement context usually relates to like seeing draft RFPs and whatnot. So I have heard of situations where while an agency is preparing for a follow-on procurement, they go, and it may even just be a casual water cooler conversation. It may not be an item within the scope of work. And they say, hey, Tony, you're the PM. You've been doing this for a couple of years. What do you think is wrong with our current SOW that we should put in the next one? If as soon as you, Tony, start providing advice to the government about what should go in that procurement, that not only is a potentially unequal access to information OCI, but it's also a biased ground rules OCI.
Okay, excellent. Thanks for explaining. Now, going to the next type of OCI, the biased ground rules. What type of situation create a biased ground rule OCI?
So as we were just discussing, it's that idea of shaping and influencing an agency's requirements. So as soon as you have the opportunity to start influencing what's in a PWS, what's in an RFP, even threshold information like whether you're going to require a new IT system or whether maybe you should have CMMI level 3 as a requirement or CMMI level 4 or, solar power versus geothermal, anything that's helping like influence the agency's direction. It could be as simple as drafting a PWS, but it could be like this example here, doing a study that helped influence what the agency would put into another procurement.
Now, I found that interesting because it's not just providing acquisition support services. It could also be providing some kind of other service, such as a study unrelated to the particular contract in question, but that somehow provided you insight on how to best perform that contract.
Mm-hmm. And that makes this kind of difficult to mitigate because if you have an acquisition support contract, it's going to be very clear at the outset, I am going to help the FDA prepare this PWS, therefore I may have a biased ground rules. If you're doing a study, you may not know what that study is going to be used for, and you may not know at the outset of that contract that you're going to have a problem if you try to bid on a future contract.
Okay. Now then, let's turn to the impaired objectivity OCI. When would the government be concerned about an impaired objectivity OCI?
The government has this concern whenever a contractor is going to be evaluating either services that it's providing or products or work that its affiliates are doing, if it has sister companies or it's a subsidiary of another company or its competitors. Because the government's going to be concerned that you may not give the most honest appraisal if you know it's going to result in more work for you. If somebody on the street said, who can you recommend for being a great protest attorney? I'd say, Tony Franco's great. But someone would say, well, you work with Tony Franco, maybe you're a little bit biased. You're not going to be as willing to recommend somebody else. So that's one way to understand how an impaired objectivity OCI happens. And some industries are more prone to this than others. In the health insurance industry, there was a spate of cases in the 90s, early 2000s where CMS contracts, HHS contracts were being protested because the same entities that were processing claims were also getting contracts to audit whether the claim processing was proper. So they were going to be looking at either themselves or their competitors or subsidiaries and judging whether they were doing things as they should. And there was a potential conflict of interest there.
Michelle, before we moved on to the next big topic, which is identifying OCIs, I was hoping that you could explain for our audience that each one of these slides that we've gone through, the impaired objectivity slide, the unequal access to information slide, and the biased ground rule slide, make a reference to FARs that discuss in much more detail what is intended with regard to these rules. But there is another FAR which we did not present here, involving OCIs where there's system engineering and technical direction. And you were explaining to me earlier why it was that you believed that this was not the kind of slide that we needed to get into. But I do want to give the audience a benefit of the information that you conveyed to me regarding that particular OCI, since many of the folks on our audience will go to the FAR, will open it up and start looking at it, and then may see this one and say, oh, this was never addressed.
Well, first, I think it's important to understand that these FAR provisions were created about 35 years ago now. And actually during the prior administration, there were proposals to change them because they don't really reflect how either the GAO or the court approach OCIs anymore. If you look at a GAO decision on OCIs, they really don't use these definitions of different conflicts of interest. They more cite how they have evolved in the case law. And then the second reason why we didn't use that other one is because that situation is very difficult to mitigate. If you are developing a system, like technical specifications plans, and then you want to compete to build that system, there isn't really a way to mitigate that other than to have a different company do it. And then you're not really mitigating it, you're just having another company step in. So these are the kinds of OCIs that we're focusing on here: the unequal access, the bias ground rules, the impaired objectivity. Whereas we'll discuss, some are easier to mitigate than others, but this is where mitigation is most common. And these are the kinds of OCIs you see on a regular basis because this is the kind of work most companies are doing, whereas that is a more niche kind of industry.
Okay, perfect. And it's one that really cannot be mitigated, so
Yeah.
Therefore it's not really within the scope of the mitigation plan.
Exactly.
Excellent. Thank you very much. Now, with regard to identifying OCI, what are the signs that there may be an unequal access to information OCI?
So anytime that as a contractor performing a contract, you're going to have access to information that could help you in another procurement, maybe you wouldn't want your competitors to have this kind of information because it's so useful. That's when you have a risk of an unequal access to information OCI. So that could be competitor pricing, could be competitor technical information, it could be government financial information, procurement information. And, for instance, this could be that you are, as a contractor, you're seeing what other contractors are getting paid, or it could be that you are looking at their systems and evaluating whether their systems are compliant with different requirements. So anytime you're seeing somebody else's proprietary confidential information or government information that has not been released to the public that could help you in another procurement, that's when you may have an unequal access OCI.
Okay, thank you.
So there really isn't one kind of unique type of contract that could give you this type of OCI. It could happen in almost any contract. It just really has to do with what kind of access you're going to have.
Okay, so then with regard to contracts or RFPs and the requirements where there's an impaired objectivity OCI risk, are there buzzwords to look for or to know where there is a risk of an impaired objectivity OCI?
Definitely. Whenever I hear someone say I've got a contract for auditing or monitoring or evaluating or assessing, those are all kind of buzzwords because they indicate that you're going to be evaluating, another company or your competitors, yourselves, services or products. And in that instance, if you are also playing in that space, so if you're testing IT systems for vulnerabilities, but you also install and administer IT systems, you could have a potential impaired objectivity OCI. So those are the buzzwords that I look for. And also making recommendations, because you could potentially make a recommendation that could benefit yourself or be a detriment to a competitor. Like if you're Dell and you make a recommendation to use HP, that could be an impaired objectivity issue.
Michelle, let me ask you, if there's an RFP that is issued that has these buzzwords in it, will that RFP normally have a provision requiring that you come up with a mitigation plan or that you address OCIs, or more often than not, are they just silent about that?
Often they will have an OCI either requiring a plan or requiring you to certify that you don't have an OCI.
Okay.
And it's becoming more and more common, and some agencies are having their own OCI provisions that they use or their own processes that they use.
And with regard to this impaired objectivity, OCI, if you're awarded a contract that involves evaluating and monitoring programs, et cetera, along the lines described here, what if the contracts were awarded by different agencies or divisions?
It's still possible that you could have an OCI, if the work that you're doing under the contract with agency A affects or involves the work that you're doing with agency B, then you would have a potential OCI. The example I was saying earlier with IT systems, if you had installed IT systems within one division of HHS, and then the HHS CTO wanted a contract to assess and evaluate all of the different IT systems that were going on within HHS, you would be potentially evaluating your own system that you had installed, even though two different entities within HHS had awarded those contracts.
Okay. Now, turning then to contracts and RFPs, requirements where there's a bias ground rule OCI. What are some signs that if I'm a contractor, that I have a bias ground rule problem?
So you'll have a bias ground rules if you're shaping this, if you have a contract that requires you to shape the RFP requirements, like drafting solicitations, drafting requirements, giving recommendations, white papers, etc. We received a question, and please do feel free to submit questions as we go along, because I know these can get a little confusing, and we encourage, we like to answer your questions if we can. One of our attendees asked for a bias ground rules. Does this only occur if the contract is paid? If a contractor voluntarily gives information to the government for free, a white paper, could that cause a bias ground rules violation? Technically no, because the OCIs happen when work done under one contract affects another. And clients do often come to us, or they do it on their own, and they work with agencies to try to shape the RFP, and that isn't being done under a contract. It's just being done as their own kind of marketing. And so that would not give rise to an OCI. If the government kind of gave you information that it wasn't sharing with somebody else, that could be a problem. But if you are, if it's a one-sided kind of transaction where you are handing over the information for the government's consideration, I don't see how that would give rise to a bias ground rules.
Okay, that's an excellent question. Thank you. Turning then to mitigation strategies. With regard to mitigation strategies, can you explain to us with regard to the unequal access to information OCI? Turning now to the heart of our presentation here. When do I need to implement a mitigation plan when you have this kind of OCI problem?
The best case scenario, you'd have your mitigation plan ready to go as soon as performance begins. You'd have it all set up and approved. And I say that because otherwise you have a cat out of the bag problem. If you start performing under this contract, the information is flowing, it's going all within your company. Anyone within your company could have access to this sensitive information, be it competitor pricing information or, draft solicitations. And then you put in a firewall 2 months later, mitigation measures 2 months later. You don't know where that information went. You don't know who it was shared with. You'll have problems documenting what happened to it during those 2 months period. So when you have a mitigation plan in effect at the very beginning, you've stopped that harm from even potentially happening by controlling the information.
Okay. And when you say it's the easiest type of OCI to mitigate, when you have a large company that has, large, or it could be small, but still with a lot of people who are getting information from all over the place on different contracts, doesn't it pose a challenge sometimes to identify these OCIs?
So when I say easiest to mitigate, in terms of addressing the concern caused by the OCI, this is the easiest problem to solve, because with an unequal access to information OCI, the concern is just addressing the flow of the information. So depending on, we'll get into this a little bit later, the sophistication of the company and the level of information, you'll have different tools that you put into place to control that flow of information, and some of them may be more difficult administratively or technologically to implement than others. But because here the goal is just simply controlling the flow of information and not how to evaluate a company without having any bias come into the process. It's the most straightforward exercise.
Okay. With regard to mitigation measures for unequal access to information OCIs, when you're developing a mitigation plan, what is the thought process that you think needs to be undertaken?
So you want to look at the information that's going to be used, that's causing the problem, and then think about all the different ways that it could be exposed to people or entities that you don't want the information to be exposed to, and then try to control and prevent that information from getting out. So, the easiest thing to start with is, well, where are the documents going to be stored? Are you going to have passwords? Are you going to have locked safes? And, depending on your sophistication, your IT systems, are you going to have separate servers? What are you going to do with emails? Those kinds of things, just controlling the actual tangible information. And then things like NDAs, non-disclosure agreements, so that people don't inadvertently, talk to other people, not realizing they're sharing this information. And then going beyond that to, where are people working? A lot of nowadays people have these open floor plans. Well, if you have information that you don't want to be shared within the whole company, you don't want your people to all be sitting next to each other. Right now we have these very large computer screens. Imagine you walk by and there's all kinds of sensitive information on that monitor. So maybe you need to have certain people in cubicles or out of the way or in different, parts of the office. And then job assignments. A lot of contractors will have people they put partially on one contract, partially on another. If they're going to be exposed to sensitive information, that may not be possible for these particular contracts. And then, employee training, making sure that everyone understands what the OCI is, why you have these procedures in place, and what needs to be done to protect the information and really control its flow. So, it's thinking in just water cooler conversations, you're with these people 8 hours a day, it's really easy for information to just start flowing. So when you're putting these mitigation measures in place, you want to just think very comprehensively about what you need to do to control the flow of information.
So we have a question here that I think you may have answered the question, but the question here is, we run the acquisition platform and programs for a particular department in the Division of Acquisition Accountability. Any ideas on how to ensure executives don't get OCI'd out, and what employees should do in regards to reporting uncomfortable internal questions?
So it's not clear to me when you say OCI'd out what the goal is. If it's a concern because you're providing acquisition support about being able to compete in future procurements, that's bias ground rules OCI. So we'll be talking about that, next. If it's a concern about executives having the access to information that they need to have and not have access to information they don't need to have, that's exactly what these firewalls can do. One of the things that we usually have in the firewall is you create a list of employees who do need to have access to this information, who are shared with access. And then if someone doesn't need to know that information, they're not on the list. It's almost like a security clearance where those need to know and those who don't need to know. So if the executive shouldn't have access to this information because it could create problems with them in the future, then you would have them not be on the firewall list and they wouldn't be, receiving this kind of information.
Okay. We have several other questions, but why don't we go to the next slide and then go back to the questions to keep things flowing. The next slide is 18, regarding the mitigation of an impaired objectivity OCI. How does mitigating, such an OCI, how does it differ from mitigating an impaired objectivity OCI?
Oh, do you mean from mitigating an unequal access, which was the last one we discussed?
Yes, that's what I meant.
So an impaired objectivity OCI is more difficult to mitigate. Here, the concern is that you may have your affiliation based on your economic interest, organization interest. Basically, you're on the team You are on ABC team and you want ABC team to do well, and you don't want your competitors to do well. So the concern is that while you are performing this contract, if you have to evaluate work ABC has done or your competitors have done, you're not going to be unbiased. You're not going to be objective. So the best way to mitigate this is to use a third party, because simply controlling the flow of information won't address this concern, because you'll still know, unless you can get rid of any demarcations that this is the work your company has done, you're still going to know that your company did it. So the mitigation measures are using a subcontractor that can help remove the conflicted contractor. I know of one protest, for instance, where the argument was, well, this company implemented these different development programs around the world, and now their subsidiary is going to be assessing, doing some monitoring and evaluation on how those international development programs are going. And the way that company avoided and mitigated the OCI was they had a subcontractor that was Firewall that was going to evaluate any of the projects that this affiliate had worked on, and the subcontractor would report directly to the government, so there was no chance that the conflicted contractor would be getting in there and saying, hey, you better give us an A+ on that program we developed in Tanzania or Madagascar, wherever it was, because of that potential OCI. So putting in that third party was the way it was done there. Depending on the nature of the contract, it may be possible to use objective criteria. Like if you were evaluating, there's one famous OCI case that dealt with these underwater sensors that the Navy was using. If it was possible to have objective criteria, like what depth can they work at, how much pressure can they withstand, that way there isn't really any opportunity for you to make subjective judgments and say, oh, well, this one's a little bit better because it does it this way. If you have very objective criteria that you can either mark yes or no, that's one way to mitigate. That requires the government's cooperation, obviously. If the government wants you to be able to make subjective judgments, then using objective criteria is going to be more difficult. And then another option similar is to obscure the identity of the evaluated entity. We're all aware of the coffee tests or the wine tests where you don't know where it's coming from, and people say McDonald's is better than Starbucks because they don't know where it's coming from. So if you have the kind of contract where you could obscure who is being evaluated and you don't necessarily know that you're McDonald's and you're tasting your own coffee, that's another way to mitigate this kind of OCI.
Michelle, could you use an affiliate to do the conflicted work?
No, unfortunately, that's probably not going to work. When you have the subcontractor approach, that third party, the subcontractor is considered independent. If it's an affiliate, there's that presumption that they're still on your team and they'll benefit if you benefit. So that strategy has not worked in the past.
Okay. With regard to the mitigation of bias ground rules, OCI, how do you approach mitigation under such an OCI?
That really depends on the nature of the contract. This is, I would say, the most difficult OCI to mitigate. If you have a large contract where developing the conflicted work, like developing an RFP, is just one task, it may be possible to use a subcontractor or recuse the company itself from doing that. The same if you had a multiple award contract, where there were task orders being issued and there were other awardees that could possibly do that work. But aside from that, this is a more difficult OCI to mitigate. So here we do have the recusal and when that's most effective. Or, it may be possible to use a subcontractor and firewalls and NDAs and government cooperation. I mean, in that context, the subcontractor would kind of be off on its side, over on the side, doing the conflicted work, working directly with the government, not talking to you about it so that you didn't have an opportunity to get involved in the RFP or the requirements that are being developed. And then it may be possible for you to bid on that work in the future.
I would imagine that if you are a small business subject to subcontract limitation requirements, you then need to be very careful if you need to now rely upon a subcontractor to mitigate an OCI. That could be a problem.
Yes, and that's why this would work most on a larger contract where, this is not maybe one of the primary and vital requirements, or it's what, there's other work that you're doing that's also primary and vital, and this is just a smaller piece of it.
And when would a contractor implement the mitigation plan?
So if you had, a max scenario or an indefinite delivery, definite quantity where you were getting various tasks along the line, then you would develop this when the OCI arose, when you were issued this request to provide assistance with preparing the solicitation for this requirement that you may be interested in competing on. Or if you have a general acquisition support contract and it just at different points during the various years of performance, the agency may come to you with different opportunities that it needs help with. As soon as that opportunity walks in the door, we would say, oh, wait, no, we need to step aside. We don't want to be working on this now. I know of some companies that have had their personnel on the back of their name badges have the kind of opportunities that they're going to be potentially bidding on, so that if anybody came to them and asked for acquisition support in those areas, they could look at that name badge, their badge, and say, oh no, we want to be able to bid on that. We can't get involved in this. Like, we can't be in this meeting. We can't have any discussions about this.
Okay, so you need to be very, very organized and plan ahead.
Yeah, I mean, because if somebody could argue that you've been involved for a week, that could be enough for them to be able to show that you had an opportunity to influence that requirement.
Sure. Okay. Well, moving to key elements in an OCI mitigation plan, maybe before we go to that one, we might want to take one of these next questions. Would establishing a corporate OCI mitigation plan to address typical information flow suffice to satisfy the particulars of a specific contract? Or would a plan have to be tailored to each individual contract requirement?
I'm a big believer in always tailoring. And the mitigation plans that I've worked on most recently, we have a corporate policy in the beginning. I think that's very helpful to show the agency that you understand the issues. But for instance, on these informational control issues, you may not have everyone on your company be subject to that firewall. So you'll need to tailor the plan for each contract with the employees that are subject to the firewall. Or if you're going to include restrictions on the future work they're going to do, that's going to depend on the contract and the issue. If you're getting exposed to information at the USDA, that shouldn't preclude you from working on a contract, with Homeland Security. So I do believe that each one, the plan, the policy can help provide a foundation for the plan, but there will need to be specific measures depending on the kind of work that's being done and the type of OCI.
Michelle, I wholeheartedly agree with you. I have noticed over the years that many clients have sent me these mitigation plans that they have put in place, much like companies use teaming agreements where there's a generic mitigation plan. I do think it's good when a company has thought ahead and put such a plan in place, because it shows that they are cognizant of OCIs that are out there. But time and time again, whenever one of these mitigation plans is shown to me as the way that they've tried to address a situation that's unique to a contract, it never covers the unique problems that contract has created. And so it's really a flawed plan because it doesn't address it. That doesn't mean that I would dissuade clients from having, sort of canned plans, but they really do need to think about how they will update them on a contract by contract basis.
And we also, one of our attendees has asked if an NDA is enough for an access to information OCI. And as Tony said, I can be a lawyer's lawyer sometimes. So my answer is it depends. But and I'll say why it depends. If you were, for instance, hiring a former government employee, or you were hiring someone from a competitor and you knew that one individual had access, that they were coming in, it's in their brain, it's in their mental filing cabinet, and you don't want them sharing that information with anyone else in the company, an NDA would probably be sufficient. But if you have a team of people working on a federal contract and they all sign NDAs, but they're storing that information on your databases, and there's papers laying around the office, and they're having meetings and they're talking about things, that NDA is good, but it hasn't stopped any of that other information from flowing. So, basically you would have to look at where is the source of concern? What is the information? And is the NDA enough to control that information? Or are there other measures that you need to put in place?
Okay, excellent. So why don't we then move on to key elements in an OCI mitigation plan? And, as the preliminary matters, I guess we need to make sure that our audience is aware of is, how extensive should the plan be?
So, in my opinion, more information is better. In my experience doing this, I've encountered a lot of agency personnel that sometimes don't understand OCIs. It may be the first time they've ever seen an OCI. So, if you can kind of lay the foundation for them and help them understand why there's an OCI risk here, or maybe there isn't, but explain that and how you're addressing it, that can help really give the agency confidence that you know what you're doing and they can trust you. And the OCI plan, when you provide more information, can also show commitment. You want to show, as one of our questioners, like the leadership, the executives can often be involved in these issues. So showing that they understand, that they have buy-in, and why, that you understand that these are a real concern to the government. And then introducing the company. Oftentimes, companies do have these kind of complex situations with parents and subsidiaries and sister companies. Government personnel don't always understand that, and they may need, to have an understanding of that so they can understand that just because your sister company, your parent company also does work within the agency, you don't necessarily have an OCI. And then back to that question about the policies, you can show that you have these existing policies and at a high level you are approaching these issues on a day-to-day basis. You're screening opportunities as they come in. You're watching your contracts. You're making sure that subcontractors you work with aren't causing problems. You're training your employees, just showing the agency that you, one, understand it, and two, you care about it.
Michelle, with regard to, introducing a company where you have to explain the corporate relationships, there are many companies out there that are run through holding entities, such as Alaskan Native corporations and tribes, Native Hawaiian organizations, where they may have multiple subsidiaries. And from your experience, and actually from mine, that can create all kinds of situations where, because of all the multiple companies they have, one entity may be doing business that could create a conflict for another. Any recommendations for how you think they can address these issues?
So that it does depend on the kind of work they're doing. We have, for some clients, put in a holding company level of review where the holding company can help screen the contracts that are coming in, the opportunities that are coming in, and then work with the leaders of each subsidiary and make sure that there aren't any OCI issues happening.
That's a great point, because in fact, I know that with regard to ANCs and tribes, they are allowed to provide at the parent level with all kinds of administrative support services. And that's a kind of management and oversight that you would think they would want to have, not only as owners of these entities, but also as good managers to make sure that these kinds of problems don't arise.
And keeping it at the high level can avoid kind of tainting. If you have an unequal access information concern, you don't want everyone at the table talking about this very sensitive work. So if you just have the executives and the holding company level handling it, it's easier to keep that mitigation process going.
This obviously holds true outside of just the world of ANCs and tribes, in terms of many companies that are out there are competing for work but have affiliated entities. Many owners we know have created multiple companies, so they need to just have one of their entities be monitoring this, I would guess, if they're not doing it on an individual basis.
And it makes sense that this would happen because, if you're in there in the trenches administering IT systems, for example, developing IT systems, you may say, you know what, I bet we do a really good job finding the problems with these IT systems. We could, create an entity that goes in and evaluates and assesses these systems too, but then you're opening yourself up to these potential impaired objectivity OCIs. So, it's a natural thing to happen that you're all doing related work, but it does need to be addressed proactively.
Okay. So then moving on from the preliminary matters, let's discuss firewalls here. If you could go ahead and discuss what kind of OCIs would these measures mitigate?
So you'll definitely want these for unequal access to information OCIs, but they're also often needed for bias ground rules and impaired objectivity. For example, in this impaired objectivity context, if you have the third-party subcontractor doing the work that you yourself, the prime, can't do, that's not going to be helpful if you're discussing the work with the independent third-party company, because they're going to have you'll be able to influence them. You'll be able to provide them information. You'll be seeing what they're doing. So you would want a firewall in that context too, and definitely for the unequal access. So as I mentioned, you would have this firewall employee list where any, staff who are working on the contract, including 1099s, whoever you are having support you on this is going to be on that list, and you're going to update it, when people leave or you hire people or they're transferred to other projects. Communication restrictions, as I said, these water coolers, meetings, you don't want to, we often deal with protected information here, and we close our doors, because if you're going to have a speaker phone, if you're going to be talking about these things, you need to make sure the information is not inadvertently being disclosed. And then how you're storing the documents, workspace separations, as I mentioned, with being able to see someone's monitor or walk by and see someone's papers on their desks. They're all just thinking about what information is out there and how do we stop it from flowing.
Okay, and how about with regard to employer restrictions? When would you want to include these kinds of measures?
These are similarly good for every plan. The firewall measures that we just talked about, business development efforts, that would definitely happen for bias ground rules or an unequal access to information. And when we say business development efforts, it's the idea that if your employees working on this current contract are getting access to information about FDA contracts, then you're going to preclude them from being on your proposal teams, being involved in doing any work, or the information they're getting under that contract would provide them with your company with an unfair advantage on that other contract. So when you're developing the mitigation plan, you provide a scope. It's almost like a non-compete. What kind of activities would this information cause a problem for? Financial incentives, the government would, even outside the OCI context, you do want to make sure you're not getting financial incentives for the work that you're doing. And then the future employment opportunities, as I mentioned, sometimes a subcontractor, or another employee will change jobs and not realize that with them could potentially come an OCI if they had information and they share it with their new employer. So letting employees know when you go on and work other places, this could be a problem.
So I think a good practice may be when you're hiring a new employee. I know that many companies will require that employee assign something indicating that they're not going to be providing with any trade secrets, any information we provide here from the prior employer, and that's understood that you're not being hired for that purpose. Mm-hmm. So I would think that you may want to add that to that offering letter.
Mm-hmm. And the same for government employees. Especially the higher level employees will often have an opinion letter from an agency saying, they can or they can't work on these things. It's also important to know, what procurements they've been involved in, or just what sensitive information they have, and they're not going to, they're not being hired to share that information with you.
Mm-hmm. Okay. Now, with regard to enforcement and administrative provisions, should these elements be included in all plans or just some plans?
For the most part, you would want to have all of these provisions in any plan. I mean, I will say the notice of intent to bid, that's the idea that as soon as you want to bid on another related contract, you tell the government. That may not be needed for all types of plans. If you're not concerned about an advantage with future work and it's just about existing work, you may not need that. Program manager pledges, depending on how large your contracts are and how you're running your contracts, you may not need your program manager to be doing pledges. But I would say every plan should have training at the onboarding stage, as you were indicating, having people understand why they're being brought in, annual trainings, refresher trainings, especially if you're getting new contracts awarded to you, the exit briefings that we mentioned when people are leaving or changing within the agency, briefing them on what restrictions they're going to be subject to and why the OCI plan provisions may continue in effect. The compliance reviews, I would think you would certainly want to have, because it helps to show the agency that you're on the ball and that you're taking care of things. And the modification procedures, this gets us back to the beginning where we talked about how OCIs are dynamic. You want to have a procedure in place to modify the plan and to get approval from the government when you modify the plan, and so that you have a good protection as you go forward, that you have an insurance policy effectively.
Okay. Excellent. Thank you, Michelle. Regarding considerations related to affiliates and teaming partners, since oftentimes that's actually where we see the conflicts, that the companies themselves didn't even realize it was a problem, and they team up with the company. Can you explain a little bit, what considerations need to be taken into account? Are there any exceptions, for example, for affiliates?
There are no exceptions for affiliates. So, you mentioned earlier ANCs and tribes. They have that exception for affiliation for SBA size purposes, but that does not apply in the OCI context. If your sister company is doing work that gave you an unequal access to information OCI, there's no exemption for you for that. The kinds of relationships we're concerned about is parent-subsidiary, common owner, subsidiary, any kind of relationship that would indicate you're on the same team and that you share an interest, and you want to look at prior work, current work, and future work, because all of those could give rise to an OCI.
Well, sure. I mean, with the way companies protest these days, I could see protesters arguing that this company that was over here did the work last year, and even though the contract is over, it may still create an OCI.
Right, because if that contract was over last year, but they developed the RFP that's in question over here, that would be relevant. And one solution that has been used by some companies is just to sell divisions, to sell affiliates, to spin off, because by selling those companies, they're no longer involved in that course of work, and going forward, they don't have that OCI risk.
Yeah, we've definitely seen that with large businesses. Many large businesses you hear are engaging in these kinds of divestments because of the recurring OCI problems.
It just becomes a very big business expense to deal with.
And let me ask you, aside from mitigation plans, can you tell our audience any other strategies that can be used for OCIs resulting from an affiliate?
So that's the sale. That's kind of your last resort, is to get, divest. Because even if, even a very firm firewall where the one company has no involvement in other company, that could work for an unequal access, but it probably would not work for an impaired objectivity.
I gotcha. Yeah. So that's a pretty draconian, but that may be the only thing you can do. Okay. How about OCIs that spread through subcontractors? Can you explain when you've seen OCI issues related to subcontractors?
So one place it's come up, and I know you've seen too, is that an agency, a CO, will come to a prime contractor and say, we noticed you have this subcontractor here and they're also doing work over here. We're concerned there's an OCI. So sometimes the agency will bring it to the attention, and sometimes it'll happen in a protest because somebody finds out who your subcontractor is, and people know generally what other companies are doing, and they make an OCI argument there. And this is a concern, if we say, at the proposal stage, because if your subcontractor had access to information, you could be using that in your proposal, and that could cause an OCI. Or it could be performance. If your subcontractor is helping you with a task on your prime contract that's related to work they're doing under a different contract, either as a prime or a sub, that could cause an OCI too.
Michelle, let me ask you then, if you are a company that all of a sudden has a contracting officer knocking at your door asking, what's going on here with this subcontractor, and you realize the subcontractor has another contract, down the hall that has created an OCI, is it too late to create a mitigation plan, or are you now potentially subject to a termination for default or for convenience?
That's going to depend on what kind of OCI you're dealing with, and where you are in performance on both contracts.
Okay.
But it can be possible still to put a mitigation plan in effect, especially if you've just been awarded this contract.
Because over the years, as we've worked on these things, we always try to look for a mitigation plan, and that's the first line of attack. And in my experience, agencies do try to work with you. Particularly if you already have the contract, it gets a lot trickier when it's in a protest. And so you now have a company out there that is complaining about the fact that there seems to have been something that occurred that was just not fair. And so therefore you have the GAO as an arbiter. And so it is harder. But even then, we've seen in protest that an agency can agree to accept the mitigation plan and resolve the problem.
And although this is outside the scope of mitigating, there is that FAR provision where agencies can waive an OCI if they want to.
Correct. That's true. Now, working with subcontractors here, a prime often chooses a subcontractor, because of its expertise or relationship with the agency. How can the prime address that risk?
So at the very beginning, you want to screen your subs. You want to get an understanding of the work they have done in the past, that they're currently doing, and that they're going to do. And then in your teaming agreement, we recommend having representations about the lack of an OCI. So if there is an issue that comes up, you have maybe a method of recourse against the sub if it comes to that, or just a means to terminate, an automatic termination if you have this OCI that can't be resolved, and require cooperation so they work with you on a mitigation plan. Similarly, in the subcontract, you want to have representations and you want to flow down any requirements from the prime contract. It may also be possible to divide up the work in a way that mitigates the OCI plan. And then ultimately, you want to either require a mitigation plan or you want to require your subcontractor to sign on to your mitigation plan.
Okay, excellent. Now, I think that basically wraps up the substance of our presentation. I know the last slide here is questions, and we have a couple other questions. I know oftentimes we have an audience will say to hear these questions, but for those of you who will want to move on, please feel free to contact Michelle or me at the 202-857-1000 or our emails, and we will get back to you with any questions, any issues that may arise regarding OCIs. But we are still taking questions. So Michelle, why don't you go ahead and take the next one that you've seen. We may not be able to get through all of them because we have a number of questions, but we will reply to you separately through a quick email in the days ahead. Go ahead.
So with regard to the blanket OCI avoidance measures I mentioned, like making somebody ineligible to compete, is there a precedent for proposing a mitigation plan anyway? So if there is an actual RFP provision that says you're not eligible or that a certain group of contractors is not eligible, that provides the basis for a pre-award protest. We have, so you can file it as a pre-award protest, or if there's enough time, you can prepare a submission to the agency explaining, why you don't believe there's an OCI, and possibly including a proposed mitigation plan showing, how you would address any issue that came up, and that may overcome the issue. And if it doesn't, you have that option of a pre-award protest, and GAO will look at whether the agency is being unduly broad and not giving any real consideration to the OCI.
Yes, because I know that under the FAR, the agencies are supposed to try to mitigate the plans and not exclude contractors.
Yes, they are required before eliminating somebody from award to look at whether it's mitigable.
Perfect. And so let's see the next question here. What are some suggestions for OCI plans where the organization is flat, such that it does not have ability to firewall a team from another? Use another subcontractor maybe?
So if you're going to, yes, I think a subcontractor may be the best option. I mean, I would like to, if you wanted to discuss a specific mitigation plan, have a better understanding of what the two contracts involved. I mean, if you're having the same people go back and forth between two contracts and getting information that could influence the ability to perform on the other, I mean, you would really need to not have the same people performing on both. So yeah, a subcontractor may be the best option there.
Yeah, if you have a flat organization, there's just no way to get around it. You need to come up with something.
Mm-hmm.
Another question I see here is, at what level in the contracting agency is a decision made to waive an OCI? Is it the CO?
It's the head of the contracting activity.
The head of the contracting activity. Excellent. Another question we have here is, will you be issuing a number for HR recertification?
I believe our support staff can provide, they almost have a continuing education requirements and they can get credit for it. So there's...
Well, yes, we'll go ahead and to the questioner, send you that information. I think we've covered all.
We did get a follow-up on the white paper. So on whether submitting a white paper would create a bias ground rules OCI. And because that white paper isn't being submitted under a contract, it's just something that you're choosing voluntarily to do. I don't see how that would cause a bias ground rules OCI, as long as it's kind of a one-way flow of information and you as the contractor saying, hey, agency, this is how we think you should do it, and then the agency chooses to do it that way. I don't see any basis for a bias ground rules OCI there.
But if they start going back and forth, then you have one.
Yeah, potentially.
That's what I was thinking too. We have another question here. We have a number of contracts with CMS who seem to be taking OCIs to another level above any pre-existing FAR clause requirements. Have you encountered a lot of contractors who have run into issues with CMS and their additional requirements? That's the question that continues. We always address and submit a complete OCI volume, which is usually required in CMS-specific solicitations since they implemented the new requirements in October 2015 with our proposals, but never receive any follow-up from the CO or anyone else from the government if we are awarded the contract. The questioner is curious to see if this is a common issue right now.
We do see different agencies taking different approaches, and I would say anecdotally, when you see an agency get burned by an OCI, in terms of a sustained protest, in the future, they're going to be more careful. So as I mentioned, CMS had a long period of time where they were getting sustained protests because of OCIs. So it wouldn't surprise me that they're asking people to do additional information. I mean, if they're not coming back to you on your volume after you've submitted it and you were selected for award, that would indicate that they've accepted it. I think if that volume includes a mitigation plan and you want to be able to share that mitigation plan with other contracting officers within CMS or other agencies, I think it would be helpful to have the agencies express approval that this approach will work.
Okay. Well, thank you, Michelle. Well, we're coming up on the hour. I know everybody has to get back to work. We appreciate your joining us for this webinar. And again, if you need to reach us for any questions you may have on OCIs, you can contact us at the number on the slide, and we'll be available for you. We've been doing this for a lot of years and are very familiar with OCIs, as I trust you could tell from the way that Michelle is answering these questions. There's a lot of cases that we've read over here regarding OCIs, so we're very familiar with the nuances involving OCIs.
And I do see at least one question that was submitted that we didn't get a chance to answer, and we'll make sure to follow up with you via email afterwards.
Yeah, we apologize for that. Thank you.